In March of 2009, I received a phone call from an attorney in Fresno. The situation that we were called in involved a young man, 23 years old, a student in Fresno, who had gone out celebrating with his live-in girlfriend.
I mean, Stephen was at age 23 at the time. He had sort of moved out and was trying to set himself up on his own. He wasn't living in the best of neighborhoods because he couldn't afford it. But on this particular day, was very excited about having done very well in school. So he was, in essence, celebrating.
They had come back to their apartment complex rather late at night. Just outside the apartment complex, the Fresno police en masse had stopped some gang members. Stephen got out and went to the trunk of his car, because it happens that on that day they had been at a shooting range, and in the trunk of Stephen's car was a .38 Smith & Wesson six-shooter. Just as he was getting that gun out of the car, these two police officers walked up to them. According to their own testimony, they got within 20 feet of him. They turned their flashlight on him. They saw the gun. They immediately pulled out their gun and they began shooting. Before they were done, they had shot at Stephen 41 times from 10 to 12 feet away.
41 shots in a short period of time seemed like a lot.
Stephen tried to take cover by running between the black car and the van next to him. And the police officers took up an initial position from about 10 to 12 feet away and began firing at him. When he eventually fell over, the younger officer, the one who was behind the red vehicle, ran all the way around the vehicles, took up the position the first officer had just vacated, and he proceeded to put 2 bullets in his back and then crow, "See that bullet hole there? I put that bullet hole in his back."
This was one of these ones you had to have boots on the ground right away. It was an active investigation scene, and so we were retaining people and making our own arrangements to be down in Fresno as soon as possible.
There were no witnesses, eyewitnesses or ear witnesses. There was nobody to testify in that entire complex that they had heard the police officers give the warnings that they claimed to have given.
It turned out to be a particularly motion-heavy trial. New motions were coming in every day. So as he said, I was having to stay in the office responding to motions that came at the end of the day so they could be presented to the judge the first thing the next day.
As in many of the cases that we deal with, they're going to want to target the decedent. They're going to want to make the decedent out to be, not reputable, and so they'll tarnish him as best they can. And that was a theme that never stopped. And of course, he's not here to defend himself.
And finally, in November of 2016, we got our oral argument before the Ninth Circuit. The Ninth Circuit upheld the jury verdict, but found there was one error, and that is that we should have been given the opportunity to get more damages than we did, because we were not allowed to get damages for the decedent's pain and suffering between the time he was shot and the time he died, which is allowable in the federal courts. So we are being sent back this year in November to try the case for additional damages. Now, everything that we have gotten so far is secured, but we will be able to get additional damages and, of course, additional attorney's fees to go with it.